Since the jury came back undecided in the Karen Reed trial, it seems that numerous jurors have reached out to the attorneys in this case, both defense and prosecution, to say, hey, we actually reached verdicts on 2 of the 3 counts. Was anybody ever going to ask us about that? Because we were only hung on the 1 count and nobody ever asked us about it. The defense made a motion to dismiss counts 1 and 3 because of the information from the jury. That was kind of a Hail Mary. I don't even think the law will allow for that after declaring of a mistrial. However, they also asked to be allowed to inquire into the jury, and they are making an argument that this violates double jeopardy because it's really the only argument they can make. They can't make an argument for new trial because she's already getting a new trial. What they want is a new trial only on count 2, because that gets rid of some of the most serious counts in this case. The double jeopardy argument is an outside argument, but this fact scenario is incredibly unique. All of this could have been resolved if the court had polled the jury. The court didn't poll the jury. The defense didn't ask to poll the jury. And now here we are with jurors who sat for 6-7 weeks plus jury selection and said, but we actually came to verdicts and nobody asked us about them. And I think that the jury instructions are confusing on this. So I understand where there's room for confusion. The Commonwealth is saying, no, the jury notes were incredibly clear, and not a single one of these jury notes said we have reached verdicts on some counts. And it's a good point. The jury never said we've reached some verdicts and we don't know what to do, which makes this an incredibly unique situation. So the defense brought a motion to dismiss before the sitting trial judge, Judge Cannoni. Judge Cannoni denied it. The defense appealed it. And on Wednesday, November 6th, the defense is having oral argument before the Supreme Judicial Court in Massachusetts, before a panel of judges. I will be covering it here on live stream bright and early Wednesday morning. We're just going to go to court. So with all of it, we have had the briefing from the defense, which are along the same arguments that we've seen in their motions to the judge. Your Honor, the jurors reached out. They said that they reached verdicts. We never polled them. We should be allowed to ask. The state is saying they never indicated they had verdicts. Too late, too bad, so sad. We're going forward on a retrial. The ACLU jumped in and said, actually, we do have some concerns about whether or not this violates her right against double jeopardy, where they've actually acquitted her, but never put it on a verdict sheet. And the rebuttal from the defense has remained, we should be able to ask the juries and the court should dismiss the 2 counts. I'm interested most to see what the judges say tomorrow and if they ask questions, because I think what the defense ultimately wants here is to be able to just inquire and go from there. Just let us ask all of the jurors. This is not unusual at this point. It has happened in multiple cases that we've covered where the jurors have been inquired from, did you reach a verdict? But you can't ask them, then why didn't you say anything? And that's the push-pull of this case. It's an incredibly unique and rare problem that, again, if the jury had just been polled, one person might have said, hey, what about those counts that we reached a verdict on? And the court could have said then, if you have reached any verdicts, go put it on a verdict form. But no, the court doesn't have jurisdiction to redo what the jury did. I don't know if there's a legal remedy here. I really don't. I'm interested to see what the court questions are tomorrow. But since that time, there has also now been yesterday, I was waiting for this. Yesterday, there was a joint motion to continue. Now, there's been joint motions to continue before that the court has denied. I don't think this one will be denied. I think it will be granted. There's a joint motion to continue, but we learned some new information, so we're going to go over that. There are updates in the civil litigation that I covered from the victim John O'Keefe's family suing numerous bars and Karen Reed for wrongful death and other things. We went over all of that in the breakdown of that suit. So we're going to update on what's going on there as well. So in the motions today and the court order that we covered for Karen Reed, The discovery that is ongoing is the reason the defense and prosecution are asking that the criminal trial, currently scheduled for January 27th, 2025, be continued until April 1st. No, I'm not joking, 2025. That includes the new prosecutor indicating that the state has multiple new experts, that they are trying to get new discovery out of Karen Read's vehicle, that they are reassembling the technological components of Karen Read's vehicle and trying to extract more information out of the Lexus's black box, which we heard in the first trial that they could not get to. They have done a new Celebrite report regarding computer searches or web searches. I wonder what Celebrite report they have rerun. They are bringing in new experts, including bringing in biomechanical engineers, and they anticipate more pretrial litigation with regard to the defense experts, the crash daddies, and their own new experts. So it seems that with the new prosecutor has come an entirely new trial strategy with a fleet of new witnesses. And it was noted in the motion from the prosecution and defense that the prosecution anticipates even more new experts. So the prosecution is completely reinvestigating this case, it seems. The prosecutor said multiple times that the parties believe additional time is necessary for both sides to prepare for trial and litigation and provide a more efficient, streamlined, and shorter presentation to the jury. So what that says to me is, Your Honor, I beg of you, please continue it, and we promise this trial won't go into the weeds. It'll be more streamlined. We'll do it better this time, Your Honor, I swear. So I think they're really trying to tell the judge, if you just give us this one continuance, we won't be here for weeks on end asking if it was snowing. Promise. And then, as far as the civil wrongful death case from John O'Keefe's estate, the court has agreed to stay the proceedings as to discovery from Karen Read in consideration of her Fifth Amendment right against self-incrimination. She shouldn't be forced to a deposition, the court said, when she is still pending a trial, though the court noted in that order, which was signed on October 31st, that the trial was going to be done in just a few months because it was starting in January. If this trial gets put over till April, I wonder if we will see the plaintiffs in that case, the estate, asking the court to reconsider this ruling, because the court mentioned in the ruling numerous times the case is going in January. It's only going to be a few months. No one is harmed by a delay of a few months. So the discovery is going to be stayed as to Karen Read and can continue on as to others. And the court pointed out that the civil lawsuit really hinges on whether or not Karen Read hit John O'Keefe with her car, which the court noted is the central issue of the criminal trial. And it is the central issue of the criminal trial. So with that, we have gone through the updates in the Karen Read case. We will see what happens when that case goes to hearing at the Supreme Judicial Court. Just for expectation management, those judges are not going to rule from the bench. We're going to have to wait on a written order. They're going to hear oral argument, and then we will get a written order later. So we might not even have an order from the court on this hearing until after January anyway. So I'm not surprised that there's already a motion to continue. I will be very surprised if the court doesn't grant it, but this judge has surprised us before with not granting continuances, so we'll just have to see what happens, won't we? For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.